Having our Thursday meeting of the House Judiciary Committee, and I welcome all of you here today. We only have one bill on the committee, and I am the first sponsor of that bill, so I'm going to be presenting it. First of all, we have again our two judges, Judge Boyette and McGarity. Glad to have both of you today. Good to have you. Anyone else for the Judiciary? Oh, I'm sorry. Justice Namias and Judge Self. Yes, sir. Well, we got a lot of judges. I got to be on good behavior today. As this is my bill, I'm going to be turning the presiding of the meeting over to our Vice Chair, Mr. Fleming, and I will do the presenting when he's ready.
Thank you,
Oh, I'm sorry. Yeah.
Thank you, Mr. Chairman. As the Chairman mentioned, we only have one bill on the agenda today, and that's House Bill 126. Mr. Chairman, you want to tell us the LC number that we're working off of, so everybody's got
Good
it?
question. We're working off of the, that's the right one? Yeah, LC 297352S. I believe that's one in everyone's folder. We also have some amendments in the folder, which we'll get to at the end of my presentation, if that's acceptable.
LC 297352S, Mr. Chairman?
Yes, sir.
Okay.
As a substitute. Okay, I think I'm just told the amendments have been incorporated within the substitute. All right, so, but we wanted to set them out so everybody would understand. There are some changes to the bill that came out from subcommittee yesterday, Mr. Fleming.
Yes, sir. So, Mr. Chairman, go right ahead.
Well, thank you. Let me first just take a moment of personal privilege to give some background. This has been a long, arduous matter that started really probably about a year and a half ago with the review of issues that we were hearing coming out of the current Judicial Qualification Commission. That is a very important body in our state. The commission is. It is the only body that is allowed to remove elected officials from office, frankly. And because of the important and vast power they have in that regard, we need to be sure that they operate in a fair manner and with due process. And we had it set up under the Constitution back in 1972 as really a truly autonomous organization, and it operated quite well for a number of years that way, and really the last several years things came to pass that brought to mind that we were having some, I think, serious problems with the way in which they conducted the business. And out of that concern, we had bills introduced, a bill last year and also a constitutional amendment. And the reason we did the constitutional amendment, first of all, was the commission was set up to say as autonomous, and they answered to no one. And I don't know of any other agency, commission, committee, or whatever from the state that doesn't have someone to whom they have to address and answer for their conduct. So the commission itself was that solely autonomous organization, and as I said before, some of the members finally realized how autonomous they were, and without having the ability to be addressed as far as conduct and changes if necessary. I guess the example I want to use as part of it is we have standards of how judges are conducting themselves called the Canon of Judicial Conduct, and that is a document promulgated by our state Supreme Court as to what are the parameters of how a judge is to conduct himself, not in making his ruling so much, but how he conducts himself as far as operation of his position as a judge. And the constitutional provision of setting up the JQC back in '72 gave the JQC the authority to promulgate what we call advisory opinions. Now realize the advisory opinion has to be based upon the canons of judicial conduct that are set out by and approved by the Supreme Court. So they are the ultimate authority of what are those canons of conduct. And there grew a dispute in this past year or so with advisory opinion put out by the JQC, and it was being reviewed by our state Supreme Court, and a dispute grew out of that as to whether or not even the Supreme Court had the right to review and determine if the advisory opinion was a correct application of the canons of judicial conduct set out by the Supreme Court. And that became an adversarial position by that body. And as I read and followed this, I could not understand how in the world they could take the position they did, but they carried on that forward. They dealt with the issue about whether or not, to what extent there would be open courtrooms. And of course, we all recognize there's a need to have open courtrooms, but there's also, I think, a underlying obligation that those courtrooms, while open, should be managed by someone who would be the judge, and in case of disruption to the court, how the judge is to handle those disruptions, and if there's more people than can be permitted in the courtroom at a time, what they do about controlling, you might say, that crowd. Anyway, that was something that just brought to the forefront, again, the problem that we were having, I felt, with the JQC. So we had a constitutional amendment last year. It passed both the House and the Senate by over 2/3 vote. It was on the ballot in November and was approved by over 62% of the voters. So I think the people of this state, through their elected representatives, as well as the voters themselves, also concurred that something needed to be done as far as changes and improvement to the JQC. We had a companion bill, which was House Bill 808 last year, that passed the House and Senate, was approved by the governor. And that bill was to really start the process of the reformation of the JQC. It was not the last word. We knew it would not be the last word. We really were waiting to see if the constitutional amendment passed, and we'd come back this year with further improvements of the structuring of the JQC. And I give that background, Mr. Chairman, just to come to the point that we do now have before this committee House Bill 126, and the purpose of that bill is to do what I'm saying, is to try and make better the structuring of the JQC and the performance of its service to the judiciary as well as the people of the state. And with that, I want to go through and talk about the bill. And although the audience does not have a copy, I'm going to reference things that we see as far as changes and improvements. First thing is, of course, Section 1 speaks of the title of this particular bill as being the Judicial Qualifications Commission Improvement Act of 2017. We separated this bill by this title from the bill that was passed last year. Section 2 begins with the language of the act itself, and you'll notice on page 1, page 2, a lot of this is not underlined. This is language that is carried over from the prior act that was passed last year, House Bill 808. But then we begin on lines 48, striking. And the reason we strike all this is all changed as a result of what we're doing in the bill. And those strikes carry over through line 93 of the bill. And then beginning on line 94, we start with the new language that we're inserting for this bill, and that is the recognizing as of July the 1st this year, the commission will be reconstituted. And this is a very important matter that we've brought forward with the structure of the commission. The commission has consisted in the past of 7 members. And those 7 members served as really the investigating group. They would receive complaints about a judge. That 7 members would do the investigation, make a review of the complaint, make a determination if that complaint was valid to go forward, If they made that determination, they would then go through the process of having interviews, perhaps with the judge, etc. If it was not something to be resolved, that same 7 members now would sit as the prosecutor, the trier of fact, and the ultimate judge of what would be the outcome of that complaint. So it frankly lacked the important element of due process. And so beginning with line 94, we are taking the commission that was consisted of 7 members originally, and we're increasing it to 10 members as a commission, but we're dividing it into 2 panels. And the first panel we left at the 7 members, which would be the investigative panel. So that panel will still have the responsibility of performing the reception of complaints, the review of those complaints, determination if there's a valid complaint, then going forward with either interviewing parties and judges, making determination what to be done with the complaint, and if they could not reach a resolution with the judge, then that particular complaint would now go to a second panel, which will consist of 3 members. And the dividing of the 2 panels begins on line 110, and you first start out with a 7-member panel, and then you'll recognize that the list of what their responsibilities are, beginning on line 121, and then it talks about the appointment of that 7-member panel, and the way it's being set up is by appointments. You have one attorney member being appointed by the governor, and that person starts out with a service of 4-year term. And then you have 2 judge members who will be appointed by the Supreme Court on the investigative panel. And then you have 2 members consisting of 1 attorney and 1 citizen being appointed each by the Speaker of the House and the President of the Senate, the Lieutenant Governor. So there's the makeup of your 7 members. You then have, beginning on line 160, a 3-member panel, which would be known as the hearing panel. The purpose of that panel would be if the matter of a complaint is not resolved through the works of the investigative panel, and there's now to be a hearing for determining what conduct the judge is accused of doing as being inappropriate, and the meeting out of some disciplinary to that judge. This would be separately done by the hearing panel. The important element here is that we do now have due process that was lacking in the manner in which the prior single panel commission was set up. So this is an important improvement to it. This is also following what we consider to be the American Bar Association model for a disciplinary panel of judges. They have recognized that there needs to be appropriate due process, and there needs to be a separate panel, and we separate to the extent that the hearing panel has absolutely no contact and involvement at all with the investigative panel. The hearing panel will be made up of 3 individuals I mentioned, 2 of which will be appointed by the Supreme Court. That will be a judge who will serve as the presiding officer and an attorney, a member of the bar of Georgia. The attorneys are to be members of the bar for 10 years, and we understand, which we won't get into now, but the bar has set up a separate committee that will be a review committee to do the vetting of potential candidates for the positions of attorneys to serve within the commission. And our hope is that will be a standing and permanent committee with the bar, because I think it's something that will need ongoing service for many years to come. So you have an attorney and a judge appointed by the Supreme Court, and then you will have a lay member who will be appointed by the governor. And the purpose of the panel is to conduct hearings. The judge will serve as the presiding officer of that panel and take whatever steps are necessary as far as performing the hearings and making determination of what will be the uh, discipline to be meted out to that particular judge. We've also added something here too. One of the things to pass that was a concern was should there be calls to have a member of the JQC removed under the former provisions of law that we had, at least constitutional language. There was no way to remove a commission member who was errant in the performance of their duties. And we have added in here the ability to have that person removed for cause. And we define cause as being under line 204 to include being an indictment for or conviction of a felony or any offense involving moral turpitude, misconduct, malpractice, malfeasance, misfeasance, nonfeasance, or incapacity, as well as failure to attend 3 or more panel meetings or hearings in a 1-year period without good and sufficient reason, or abstaining from voting unless recused. I think one of the things we found out during our review of the commission work this past summer by a House committee that we have was from time to time commissions would hold meetings and people would be allowed to consider being present by telephone. And we didn't want to have this any further. We felt the people need to be present at the meetings when they're having a interview or conducting the business of a judge before that body. And we said that the removal of a panel member for cause shall be by a unanimous vote of all the officials having the authority to appoint members of that particular panel. We had that inserted to be sure that we removed any question about politicizing appointments to the commission and having, say, the speaker or lieutenant governor or the governor by their own voice and reasoning to have the ability to remove someone. So in effect, on the investigative panel, for instance, if there was to be a panel member removed, it's going to require the Supreme Court's approval, the lieutenant governor's approval, the governor's approval, and the speaker's approval. So that would be 4 persons that have to say, yes, we're going to base that removal on cause as defined in the law, as well as agreement of those all individuals. A quorum of the, under line 211, a quorum of the investigative panel would require at least 4 members to be present to conduct the business. As I mentioned, they cannot do it by telephone. We've also said decisions of the panel shall be by majority vote. As I mentioned earlier, we expect all the commission members to vote on matters. Recusal can only be done by, as I believe the language is, having a other members of the panel accept the fact that a person has a cause to be recused, in other words, not participate in a hearing if it comes before the investigative panel or the hearing panel. They will promulgate their rules, but all their rules will be subject to the approval. This is the investigative panel and the hearing panel. Their rules will be subject to review by the Supreme Court of Georgia. We also, on line 253, section K, started into the discussion about the confidentiality of disciplinary actions regarding a judge. This is all information regarding a disciplinary or incapacity matter of a judge shall be kept confidential by the investigative panel and commission staff before formal charges are filed. And say, provided, however, that if a prior filing of formal charges, such judge and investigative panel agree to a satisfactory disposition of the matter, a report of such disposition shall be publicly filed with the Supreme Court. This is a step different from what was being done in the past. In the past, if you had a judge who accepted a form of discipline, it remained within the commission as a confidential record. Now, even if there is an agreement to resolve the issue with the investigative panel, and there will be a disposition to be made where they were either a letter of reprimand, some form of suspension, whatever, that will still be now filed as a document with the Supreme Court, becomes a public document. We want to recognize that the incapacity of a judge, meaning that if they had senility or the problems that were be causing them not to be able to perform their services, that would still remain confidential because it may also involve medical records. And we felt important that the ability that that judge and his family keep the information from not becoming a public matter. But with respect to a disciplinary matter of a judge, all pleadings and information shall be subject to disclosure to the public, and all hearings and proceedings shall be open and available to the public. This was also a very important matter as far as transparency that we wanted to carry forward with the law regarding the fact that when there's a hearing done, there will be open hearings. I might also add that in the past, the JQC had kept all their meetings closed. In other words, even when they had a meeting on administrative matters, they would not allow the public to come in or be a part of that. So even preparation of their budget, those matters were closed off. So looking at line 264, we addressed that. We said with respect to administrative and other matters, all records and information shall be subject to disclosure to the public, and all meetings or portions thereof shall be open and available to the public, except to the extent that such records, information, or meetings would disclose disciplinary matters of a judge that's protected under the law, and disclose incapacity matters of a judge protected under the law, and be considered a matter subject to executive session if the commission were to consider to be an agency. This would be matters such as if they're considering personnel matters, that would be closed to the public. Also not be required under the provision we have dealing with open records where there are exceptions made to that. The beginning on line 278L, we talk about the notwithstanding subsection K of this code section, information regarding a disciplinary or incapacity matter of a judge may be disclosed, or the confidentiality of such information may be removed when. So we realize there may be times that this information has to become public, and one is the privilege of confidentiality has been waived by the individual, meaning the judge, who was the subject of the commission investigation. Now, why is that important? Because from time to time, a judge who may be under investigation goes public with that information and disclose the fact that he's being harassed or something, we'll call it, by a commission. Well, the commission should have a right and ability to respond to those type of allegations. So that's one reason. Also, the commission rules may provide for disclosure when in the interest of justice and to protect the public, and when an emergency situation exists, or when a judge is under consideration for another state or federal position. The last part is because we have had times in the past where a judge may be under consideration for a new position, and the state has a judicial nominating commission. They've wanted to get that information and were denied that information. So we felt that was something, again, important, as well as when you have a federal position open and one of the judges being considered for that. So that was, again, why we inserted those type of exceptions. We also, under section N on line 305, say a respondent, meaning the person against whom a complaint has been alleged, who is recommended for public reprimand, censure, suspension, retirement, or removal, shall be entitled to a copy of the proposed record to be filed with the Supreme Court. So it becomes record, and the respondent has objection to it, to have the record settled by the hearing panel's presiding officer. So if there was some question about what is appropriate to be filed or not, the hearing officer for the panel, that would be the hearing panel, would make that determination. So again, to be sure that we kept those records open as to the extent necessary. One last thing we have, and this is something that's come to pass with regards to on line 320, section O, we have learned in the past of occasions where a judge who was under investigation and you have a commission member who is an attorney appearing before that judge, the other party would not be aware of the circumstances. I mean, you've got two individuals before the court, plaintiff and defendant will say, and you got a judge who's presiding, an attorney representing the JQC, or I'm sorry, not represent, a member of the JQC is appearing on behalf of one of those parties. And the other party, of course, will not be aware of that fact. Well, we want to be sure that that judge did not hear that matter. It should not be, because there is certainly an interest potentially of that judge independence being compromised. So we say when a judge knows that he or she is under investigation by the commission and the commission member is representing a party before such judge, the judge shall be disqualified from presiding over such matter. One last point, Mr. Chairman, and I'll close out to take questions, but we've also have the director of the commission, who is by this law to be a member of the bar, is also going to be serving pretty much as the prosecuting attorney if a matter goes before the hearing panel. And unlike in the past, we have that director is no longer capable of practicing law outside the commission. So his duty will be confined to work on the commission. So you will not have a director going before judges in a legal capacity, which also I think would raise some question of the ability of that judge to properly hear a case by that attorney. With that, Mr. Chairman, I will be glad to answer any questions.
All right, thank you, Mr. Chairman. Are there any questions, Chairman Willard, by members of the panel? Representative Evans.
Thank you, Mr. Chairman. Chairman Willard, I just had a question about the differences in the investigative panel and the hearing panel. I think is great, and I commend. And let me start by saying I commend all the work that you did on this. I know it's been a long journey.
A lot of people helped out with it, I assure you.
A lot of people have some opinions, I know. But I noticed in the bill it says that there shouldn't be any ex parte communications between the members and staff of the investigative panel with those on the other panel. But there's no direct statement in the bill that those staff member there's statements in the bill that make it clear that the members of each panel should be different people, but there's not anything that says that the staff members should be different people. I was wondering if you would be amenable to some language to make that clear. Perhaps I was trying to find like between lines 192 and 193, just adding a separate subsection that makes it clear that the hearing panel and the investigative panel shall have separate staff.
Well, we thought through that at some point in the past, Ms. Evans. We did not go into the might say into the weeds about who they hire, but yes, there still may be a potential staff employment by a hearing panel. The point being here, if you have a hearing panel, we don't expect them to be that active, frankly. And I mean by that, I think in the history of Mr. Davis's hearing, correct me this, but we had maybe 3 cases in the last maybe 5 years or so have gone to a full hearing situation. So our thought is you probably won't have full-time staff for that hearing panel. The expectation is they're not going to be, again, that active. But when they do become active, I think they can employ part-time or receive help from an agency of the state that will give them whatever staffing assistance they need for that time. But not use the investigative panel staff. But we just didn't go into trying to explain that in the bill.
I wonder if we could just do it instead of making it sound like you've got to have full-time staff on both, just saying at no time, sort of writing in the negative, at no time shall the staff members of the investigative panel serve as staff for the hearing panel. It's just a thought. Because otherwise, all you're really doing is precluding somebody from having a conversation with themselves. But you're not really saying that they have to be different people.
We can consider that one.
Okay. And one other question, if I might, and I don't know how to fix this issue, but the last subsection O, starting on line 320, we've got everything being confidential, But then if a judge knows that they're under investigation, they've got to recuse from the from a case if there's a commission member hearing the case. And I'm wondering how they can do that without getting rid of the confidentiality.
I think a judge can say, and when I ask one of the judges, you just say, I'm recusing myself from this case, period. And they don't have to give an explanation.
Yeah, and that's
So
my
it's not a
question.
call-
I don't
it's
know
not
if
a
they have
call.
to.
He is guided by his conscience in many cases. He or she is by their conscience in many cases by either relationships, investments, or whatever it may be. So a judge could say, I'm recusing myself, and that's all he or she has to say.
Judge Boyette over here is nodding his head. That's correct. Mm-hmm. You can't see him. He's right behind the pole there.
I know what he looks like. That's all right. Okay.
Yeah, we thought that,
Perfect.
and that was why we left it that way, let the judge say it, as opposed to the attorney say, Judge, you are under investigation, and we're not going to. You're not qualified to hear this case. That's the end of it. Mm-hmm.
Okay.
Thank you, Mr. Chairman.
Thank you, Representative Evans. Any other questions from the committee for Chairman Willard? Okay. Mr. Reed, do we have anyone signed up?
I was pointing out something. I mean,
Of course. Go ahead, Mr. Chairman.
I think maybe if I misstated, I apologize. But I was saying about the 4 members appointing on the investigative panel. If there's to be a removal, only those 4 involved. Same is true on the hearing panel. You have what would be 2 parties. You have the governor and the Supreme Court. So if you had a need to remove a hearing panel on that body, it would only take those 2 parties.
Okay.
Sorry.
No problem at all. All right. Well, if there are no other questions from the committee, we do have one person that signed up to speak. Pat O'Connor, Mr. President of our State Bar, please come forward. We appreciate you being here again today. You were here for subcommittee also. You just spend the night up here, or did you go drive back and forth to Savannah?
Oh, no, I spent the night up here,
Well,
Chairman
good.
Fleming.
Well, good. It's not that short of a drive, is it?
No, and as I told you yesterday, I think I've grown to know every crack in the road between Savannah and Atlanta over the last 6 months as bar president, but it's a pleasure to be here today.
We not only appreciate you being here, but once again, we thank you for your service to the bar and the state. Please feel free to share with us.
Thank you very much. First, Chairman Fleming and Chairman Willard and honored representatives, thank you for allowing me to come here on behalf of the State Bar and speak to you. I am Pat O'Connor, the President of the State Bar of Georgia. As I told you yesterday, my vantage point in this topic comes both in my role as President of the Bar and from my experience as a lawyer practicing before courts all over the state. My practice is primarily a civil litigation practice that involves going to court and representing litigants in court, primarily defendants, but I do represent some plaintiffs as well. And I've been before many judges around the state over a period now of, as I said yesterday, longer than I'd like to count, some 35 years I've been doing this, so I've seen a lot of judges. I have high respect for the judges in Georgia, and on behalf of the bar, I want to say we have a wonderful and good judiciary in this state, and we are pleased to be part of this effort to improve the JQC. And I do believe that at the end of this process, we will have an improved JQC. I think the judges of our state deserve a high-quality JQC. The citizens of our state deserve that, and so we are committed to helping in the process. And we believe that most of the proposed changes here are good, particularly the one that was mentioned earlier about dividing the JQC into an investigative panel and a hearing panel. That is a particularly good idea, given the, as you pointed out, Chairman Willard, that in the past our practice was simply to have the investigative panel act as investigator, judge, and jury. And so that will be a tremendous improvement, we think, in the process. Since the JQC was created in Georgia in 1972, the State Bar of Georgia has had direct appointments of the lawyer members of the JQC. I'm here today on behalf of the State Bar requesting that aspect of the bill be revised so that the bar continues to have direct appointment of the lawyer members of the JQC. In support of our request, I want to talk about really 3 topics. First, our request that the lawyer members of the JQC be appointed by the bar is consistent with the American Bar Association's model rules for judicial disciplinary enforcement. The ABA model rules address many aspects of a proposed JQC. Yesterday, Representative Dreyer asked me a question about what the recommendation of the ABA was on the number of members of a Judicial Qualifications Commission. And I mentioned that it was up to 12 and that many states have differing numbers. Today I want to just read you the direct language from the model rules about that and how the appointees are originated. This is in the model, from the model rules of the ABA, Rule 2C, and this would be the model rule if adopted. The Commission shall have 12 members who shall be residents of the jurisdiction where the JQC is located. 4 members shall be judges of the intermediate appellate or trial courts appointed by the highest court of that jurisdiction. 4 members shall be lawyers admitted to practice in the state appointed by the Bar Association of that state. And 4 members who are neither lawyers nor judges shall be public members appointed by the governor. So that's the specific model rule that is suggested by the ABA. We believe that the model rule is sound and that the House Judiciary Committee should consider following the model rule. The second point I want to make is this. Our request that the State Bar have the direct lawyer appointments is consistent with what our sister states in the Southeast do. There's only one state contiguous to Georgia that does not utilize the direct appointments by the bar, and that's the state of Tennessee. But in Tennessee, the bar is not mandatory. And so it's natural that Tennessee would not have direct lawyer appointments because not all lawyers who are members of the bar in Tennessee, or the bar does not include all the lawyers of the state. In Georgia, we have a mandatory bar. And so that leads to my third point, which Chairman Willard mentioned earlier, which is our improved vetting process. Back in June, when I first became president of the State Bar, I appointed a task force to help the bar identify and vet potential JQC nominees. And that task force consists of leading lawyers and some judges from around our state who are not only involved in bar leadership, but some who are not. And let me just mention 4 or 5 of the names of the folks that are on that task force. Judge Diane Besson, Judge Tony Del Campo, Scott Delius, Harold Franklin, who's the immediate past president of the Atlanta Bar Association, Judge Horace Johnson, Ed Lindsey, who I believe is in the room here with us today as a member of our task force, Pete Robinson as well. And so that task force was created not just from bar leadership, but from lawyers in other leadership positions around the state. Because our bar is mandatory, the approval by the Board of Governors of names nominees to the JQC necessarily means that we have the input of every lawyer in the state of Georgia. And so in the vetting process, we first begin with the task force, which receives names from lawyers all over the state, from every corner of the state. Then the task force vets those names and submits a list to the Board of Governors, which must then, at an open meeting, itself vet those names before a nominee is offered or nominees are offered. And so the vetting process is very thorough. It goes through a process that was not in place before. As you pointed out, Chairman Willard, in the past, generally the JQC nominees from the State Bar were the result of the President of the Bar nominating someone and the Board of Governors approving it. We have a much more thorough system in place now. And so we think that any problems that may have crept up in past appointments would be solved through this vetting process. In addition to that, this vetting process allows us to identify the lawyers who have the experience, the temperament, the time, and the work ethic to participate in this very important job, because it is time intensive and it is a very rigorous process. It's not something you can take lightly, and so we need to identify those people who have the time and the temperament and the willingness to take on the job. As my colleague Ed Tolley, who is one of our State Bar appointees, said, no one knows the lawyers of Georgia better than the State Bar of Georgia. I think Ed was exactly right about that. We've had a good record of appointments in the past, and I would just like to take a moment to mention a few of those that, even though we did not have the vetting process that I've just outlined, the State Bar's appointees over the past 44 years have been, I would say, stellar. Here are some of the people we have placed on the JQC. Ben Easterling, who is the newest director of the JQC. Ben is a past president of the State Bar of Georgia. His integrity is unquestioned. Jim Durham of Brunswick, a past president of the State Bar of Georgia. Robert Ingram, Frank Jones of Macon. And as I said to the subcommittee yesterday, Frank Jones was not only a giant in the Georgia bar, Frank Jones was a giant in the American bar. Frank Jones was well known by first name to every U.S. Supreme Court justice probably over the last 30 or 40 years. He was a State Bar appointee to the JQC. Bob Reinhardt from Tifton, Will Ed Smith from Eastman. And I like to talk about Will Ed because I worked for Will Ed Smith one summer when I was in law school, and I learned a lot. He was a State Bar president, if I'm not mistaken, in 1964. 64, the second year we had a mandatory bar, Chairman Willard. He was the second president of the mandatory bar in Georgia. So those are just a few of the examples of appointees we've had over the last several years. And so in conclusion, what I want to say is the State Bar of Georgia supports pushing forward with an improved JQC. We support virtually all aspects of your proposed bill. The one area that we are asking you to consider making some changes is in the appointment process to return to the bar the direct appointment of the lawyer members. Finally, I want to say to you that we also support seeking adequate funding for the operation of the JQC. Chairman Fleming and Chairman Willard, we have discussed that there will need to be adequate funding in order to sufficiently and adequately operate this JQC.
You got the man right here that can do that.
Good.
We've asked for that information for 2 years now.
The information about the cost of operating the JQC? Well, I will tell you this. If the request had come to me as president of the bar, you would have it. And now that I know you're asking for it, I will make every effort to see to it that you get a response to that inquiry. So I will be happy now to answer any questions there may be.
Thank you, Mr. President. We appreciate, like I said, being here. Any questions for the President of the State Bar from members of the panel? Okay. Thank you so much for coming today.
Thank you very much, Chairman Fleming.
I do not believe that we have, Mr. Chairman, anyone else signed up on the sheet that I was given, so we will bring the bill back to the committee at this time. Any other comments, Mr. Chairman, you'd like to make before we move ahead?
Yes, if I may, please. Let me, I want to go to further explanation regarding our bar president's comments. And I sit here as a member of the bar, which I have been since 1965. And I appreciate the bar even has been kind enough to recognize me for my service. And I'm sitting here really sort of unusual situation, but let's be mindful of the fact that we have not totally excluded the bar. We have recognized the bar is to do the vetting and submit names for the appointing officers, including the Supreme Court, to draw from in making their selections. I want to go to a concern that we had as far as the preparation of the bill, and there's a case which I think most of the people who have been involved with this are familiar, which is the Rogers versus Medical Association of Georgia case, and that dealt with the ability of a organization to make the recommendation for the governor to make an appointment to a medical body, and there was a challenge made by a doctor who was being disciplined by the medical board, and the Supreme Court of our state recognized that there's a limitation on that ability of organizations to make the recommendation by which the appointment, I said by recommendation, they made a statement, here's a name, Governor, appoint this person to the medical board. We don't have that situation here. We have the bar making a list of potential recommendations from which the appointing officers can make their selection, but they're not required to make the selection at this point in time. And what the case said was the Constitution provisions mandate that public affairs shall be managed by public officials who are accountable to the people. The importance of this power is emphasized by the constitutional provisions by which the people initially granted their chief executive, the governor, the power to fill vacancies in public offices unless otherwise provided by law. And what they talk about, the power here is the General Assembly under the Constitution has the power to make laws consistent with this Constitution and that are not repugnant to the Constitution of the United States, which they shall deem necessary and proper for the welfare of the state. And they limited the fact that by this decision, the ability of the outside parties to have that appointment power. The controlling languages under the decision is our opinion. It is clear that the constitutional provision cited above demand that the power to appoint public officers remain in the public domain. The General Assembly may, within constitutional limitations, establish qualifications for public office and designate a governmental appointing authority, but it cannot delegate the appointive power to a private organization. Now, that is part of what addressed the issue for how we worded this, and I want to say the other underlying factor is we want to prevent there being a challenge by a judge who's been disciplined and perhaps removed, as I said, from the very start of this thing. This organization, the commission, is the only body that has the ability to remove an elected official in Georgia. Only one. The only way you can remove somebody who's elected, of course, there's some things in the law, if they perform criminal conduct, that it could be removed, but it's very difficult to do otherwise. So we did not want to leave open a potential way to have a challenge made to the action of the commission, and we felt the appropriate thing was to have the bar do the recommendation, and out of that recommendation have the appointing parties, officials, to select an attorney for that position. Thank you.
Thank you, Mr. Chairman. All righty. Probably time for a motion now. Is a motion regarding House Bill 126, LC 297352S.
Do pass, Mr. Chairman.
There's a motion. Is there a second? Discussion? Amendments? Hearing none.
Actually got Ms. Evans.
Ms. Evans, I'm sorry. Go ahead, Ms. Evans.
Thank you, Mr. Chairman, and I support the bill and will be voting yes. I did just want to bring back up the concern about the making sure that we keep the solid improvement that we've got here with the separate panels, and to that end I have two proposed amendments. The first would be on line 181 to add after the word terms, or I'm sorry, after the period, a new sentence that would read, no member serving on the investigative panel may serve on the hearing panel, so as to avoid someone getting appointed to the investigative panel, serving their term, and then going on to the hearing panel and potentially causing the issue that we don't want to cause, which is having the information from the investigation.
So your amendment, read it to us one more time if you would.
Sure. No member serving on the investigative panel may serve on the hearing panel.
So if the Speaker of the House appointed someone to the investigative panel and their term ran, he would not be allowed to appoint them to the hearing panel if he so chose on your amendment?
Correct.
Okay, there is a motion as an amendment. Is there a second?
Second.
There's a second discussion.
Good point. Thank you.
Ms. Travis, would you say that one more time real quick so we?
Change the may to shall, because if you're really prohibiting it, you have to have shall. May
Yeah.
lets it go either way.
Okay, all right. Do we have someone in over here?
Mr. Kelly.
Mr.
Yeah,
Kelly?
Mr. Chairman, I'm just trying to make sure I have the language right. Is it just saying no member serving on the investigative panel shall serve on the hearing panel?
Yeah.
Should we have a then serve? And yeah, that is a question I have too. Are you meaning, are they barred forever or for a period of time following?
I was thinking forever, just to make it clean and easy, but that would be a little bit more complicated. I'm not opposed to it, just trying to make it simple.
Okay.
Any other
do have
discussion regarding
Ms.
the proposed amendment?
Ms. Beskin had hers.
Ms. Beskin?
Should we also have when considering that amendment, should we also have a correlative provision that no member serving on the hearing panel shall serve on the investigative panel?
Let-
No member serving on the investigative panel shall
That's what we're talking about.
ever or subsequently shall ever serve on the
Let me ask a question about that. What are we trying to, what are you trying to accomplish with the amendment? I've heard you mention it, but I want to make sure I understand that.
I think there was a lot of work to go into making sure that we kept the investigation separate from the hearing.
Right.
To make sure that we do that.
How would the investigations ever conflict with the hearings, given the way it's written now?
Well, if a member served on the investigative panel, served 2 years, and then left, and then got appointed immediately to the hearing panel, I think there's a strong likelihood that they could have been involved in an investigation that ends up for hearing.
But that's not what you're prohibiting with this. You're prohibiting someone from serving a 4-year term, doing a great job, and then one of the appointing bodies, the governor, the speaker, lieutenant governor, from putting them back on there again in the different panel.
Right, which
Maybe.
accomplishes what you could go from hearing to investigative, but you couldn't go from investigative to hearing.
Mr. Chairman?
I want to just respond. I think is trying to use a large thing to kill what may be a gnat situation here, because if you had that even to happen, if there was a case coming up from the investigative panel to the hearing panel, and let's assume that there's somebody now on the hearing panel that had served on the investigative panel, even during the time that there was a consideration of that particular complaint against the judge, that person would have to recuse themselves from being able to consider it, because that's what we give you. That's part, just like you say, with the judge recuse himself. If they have prior knowledge of the circumstances by which this particular judge is being disciplined and served in the investigative panel, their obligation is to recuse themselves. I think the rules of the panels would probably cover that point, as opposed to spelling it out in the law.
Is that, that may be completely right, is that in the legislation?
Well, we have them able to promulgate rules, yes. Both panels have the ability to promulgate their rules, and those rules are subject to approval by the Supreme Court. And I know we got Justice Namias here, but I'm not trying to put him on the spot, but I would think that'd be something that the rules themselves would address it, where we're setting up here pretty much is more structuring of the panels and not getting down to the weeds about that type of situation come to pass.
Right, and I have great faith in Justice Nagel to do the right thing. I just, we're being very specific, and I don't know that I can do it on the fly right now, but, to put in language that just would instruct that the rules be consistent with having the panel separate, but I understand your point, so I'll just leave the amendment and we'll see.
All right.
But I understand, and I'm not trying to, I'm really not trying to cause any problems with it, I just wanna make sure that our intent stays intact,
You didn't get your,
with the separate panels.
okay.
Other
One
comments?
more.
Somebody's flashed.
Who's over here?
Mr.
Yes, sir.
Chairman Powell.
I agree with the chairman regarding the conflict issue, except for the fact that if you've only got 3 people on the panel and you conflict one out, that's
Oh,
problematic.
Well, they would replace that person. When you have a member being recused, there will be a replacement of that individual.
Then I'm good with it.
Yeah, wouldn't be just 2. Still requires 3 for full hearing panel.
So Ms. Evans, I just want to make sure I understand you. Did you want to move ahead with the amendment, or did you want to withdraw it?
Well, if I could ask another question, Chairman
Of course.
Willard,
Certainly.
the person that's recused gets appointed, a new appointment by the person that appointed them, I'm assuming?
No, it's the person who placed them on the panel. For instance, you have a judge and an attorney, that would be by the Supreme Court. And there would be, if they're recused, then the Supreme Court would find a replacement. If it's the lay person, then the governor would find a replacement.
And they
for
would
that
just be
hearing.
I'm sorry, they would just be a temporary member for the
Correct.
purposes of the one hearing.
Correct.
Yeah, I think that takes care of it. I just want to make sure that the recusal would apply to information learned as a prior member, and that is a rule issue. So, yeah, I'll withdraw the amendment and try to work and make sure I'm satisfied, and we can work on it in the Senate.
Okay.
Famous last words for the
Thank you,
Senate.
ma'am. Any other proposed
I
amendments?
do have one other one.
Representative Evans.
This is in the same vein, but this deals with staff, and the next amendment would be to insert language between lines 192 and 193 to add a new subsection that would state, at no time shall staff of the investigative panel serve as staff of the hearing panel.
Without seeking for or against it, why make it a separate section as opposed to part of Section H?
I think it could be part of Section H, if that's easier for drafting purposes.
And I didn't catch it all, what you're saying at that time.
If you would restate that, Representative Evans, please.
Sure, Mr.
Make sure
Chairman.
Ms. Travis has it.
At no time shall staff of the investigative panel serve as staff of the hearing panel.
And where would we add that again, on 192?
And that would be at the end of line 195 before,
190.
after the period.
After 195, another sentence under Section H.
Yes, Mr. Chairman.
Okay. All right.
Well,
Is
Let's read Section H. So,
let's see if we get a second first, Mr.
yeah,
Chairman.
sure, excuse me.
All right. Is there a second?
Second.
There's a second. All right. Discussion. Go ahead, Mr. Chairman.
I think Section H says that. It says members and staff of the hearing panel shall not engage in any, this is not just a hearing panel, shall not engage in any ex parte communication regarding a disciplinary or incapacity matter of a judge, including with members and staff of the investigative panel. It says that.
Well,
So you got separate panels.
I think it is.
You got separate panels and you have separate staff. There cannot be a communication between, and so you won't really have a staff member of the hearing panel also being a staff member of the investigative panel.
I think that it's most likely that that's true, but really we haven't said they have to be separate staff. We've just said that they couldn't have, for example, if I was a staff of the hearing panel and I could also be staff of the investigative panel, I just couldn't have conversations with myself, which I'm apt to do from time to time.
Well, I think also we have to have a reasonable interpretation of what the statute says. And a reasonable interpretation would indicate that you wouldn't have the same person doing that, because it would be automatically ex parte by its very nature. And once again, we go back to the chairman's thoughts initially, is that, the Constitution says we have to be here as a legislature the second Monday in January, or rather the first Monday after the first Tuesday in January, and it says we have to adopt a budget, the code gets a lot more specific about the things we have to do. But then again, it also allows us to make our own rules to govern ourselves in a reasonable manner. So, you know, you don't want to get too specific in the Constitution where it should be in the statute. You don't want to get too specific in the statute where it should be in the rules. And although I appreciate what you're saying, I think the statute could probably be reasonably interpreted to, as the chairman has mentioned,
Yeah.
for them to adopt rules that would accomplish the goal of the statute.
Let me speak up on the point again,
Yeah,
Mr. Chairman.
absolutely.
We know that the investigative panel will have permanent staff employees. No question of that. They've got today 500 complaints they need to go through. So we're well aware there will be staff employees for the investigative panel. We don't see there being a permanent need of panel members for the hearing panel, but when a time comes that there become a need for a hearing, I think the panel would turn not to employ as the investigative panel because they're prohibited right here, but they would turn maybe to the administrative offices of courts, which they're going to be housed in, as a way of saying we need to have two people to help us go through documents or something to serve in a temporary basis for that type of need. But I think really I do, Ms. Evans, I think the language clearly recognizes there cannot be the same people serving as staff members of both panels.
If I might, just one
Please,
quick point,
Representative Evans.
Mr. Chairman. I just envision a scenario. I think you're right. I think there's a lot of investigations to be done, and there's going to be there'll be multiple members of the investigative staff, and without specific language, a member of that investigative staff could be moved over to the hearing staff, and all we've said is once they're moved over, they can't have communications, but we can't force them to disavow the knowledge that they obtained while they were on the investigative side. And so that's what the amendment is meant to accomplish, and it doesn't imply that you have to have hearing panel staff full time. And
Well, I want to get speak to
Absolutely,
that.
Mr. Chairman.
I just want to recognize people got common sense that you put on this 10 members, 3 of which are on the panel as being hearing officers. Why would they allow to have someone come over as an investigative panel employee, knowing that we've set out in the law these 2 separate panels that cannot have communication themselves? Now they're expecting to allow an employee to do it. I mean, just common sense tell you that would not be a logical thing that they're going to let happen.
Okay. Is there further discussion regarding the proposed amendment? Mr. Travis, you want to read that back to us and make sure we all got it, please?
At no time shall staff of the investigative panel serve as staff of the hearing panel.
Okay, any further questions? If not, we'll go ahead and vote on the matter. All those in favor of Ms. Evans's amendment, please indicate by saying aye.
Aye.
All those opposed, no.
No.
Chair believes the noes carry. Any other amendments before we vote on the bill? Any other further discussion? If not, we'll call the main question on LC 297352S. All those in favor, please indicate by saying aye.
Aye.
Any opposed? The bill passes the rules. Thank you, Mr. Chairman.
Thank you. Thank all the members of the committee. Appreciate you.
And I think we're adjourned.